Hey, welcome back. We are here. We are continuing our review of the Richard Allen appeal, the Delphi murders. Got a bug. We are reviewing the state's response to the defense's appeal filing. All right. I'm not sure how much more we have to go. Thank you for being here. I hope this is helpful. I love the law. And if it's exciting for you, I'd love to hear below. Please let me know if you have any questions. We're going to continue here. So the state says that the order and settlement agreement from an unrelated lawsuit, the DOC, was properly executed against the DOC. I think that's that other one that we've been talking about. Not sure why they've included that because we don't know what that is. I think it's this IPAS settlement here. So the state says, just as the ultimate ruling at a pretrial suppression hearing is no longer at issue following a completed trial, so also are subsidiary evidentiary rulings made during the course of the pretrial suppression hearing. The available issue now is the evidentiary rulings made during the trial, but Allen challenges only the exclusion of the IPAS order settlement agreement at the suppression hearing. He cites no authority to support the contention that this is a live issue for appellate review, and he makes no cogent argument addressed to the IPAS ruling at the trial. This court should find the issue moot or waived, and I don't know what that IPAS settlement is. Regardless, this is the state's rebuttal. At both the suppression hearing and at the trial, Allen was allowed to elicit evidence regarding the DOC's policy limiting offenders with SMI to 30 days in restricted housing. The reason for that policy, parentheses, the detrimental effect to mental health caused by social isolation, parentheses, the undisputed facts that Allen had diagnosed mental health conditions upon entry to the DOC and met the definition of SMI in April 2023, and that he remained in restricted housing for approximately 13 months. So that's 12 months more than per the policy. So potentially there was some determination in this IPAS lawsuit that they want applied or something, not sure. He was also permitted to present expert evidence regarding his mental health and the impact of social isolation on mental health. The only thing excluded was the court order and settlement agreement from an unrelated civil lawsuit that was the original genesis of the DOC policy. Okay, so maybe they were arguing somebody else's case. Thus, Allen was able to introduce the evidence relevant to his voluntariness challenge. Current DOC policy in effect during Allen's pretrial incarceration was relevant and was not excluded. A settlement agreement from an earlier unrelated lawsuit, which appeared to have expired before Allen's arrest, was not relevant. And any minimal probative value it might have possessed was outweighed by the dangers of unfair prejudice and confusion of the issues. Allen acknowledged there were a quote, lot of things in the IPAS settlement, that don't have anything to do with this particular case, end quote. And that he wanted to use the IPAS documents to attack the DOC's history of treating mentally ill offenders. This criminal trial was not the proper forum to litigate a civil rights challenge to the way mentally ill individuals are treated in the DOC. The DOC was not on trial here, and the court properly refused to allow Allen to attempt to confuse the issue the jury was to decide. Finally, any error was harmless. They state Indiana appellate rule. Given the nature of the evidence Allen was allowed to present and the lack of any coercive state action, the court can be confident that the IPAS settlement or IPAS lawsuit documents would have made no difference to either the trial court's ruling that the confessions were voluntary or to the jury's evaluation of the weight to give those confessions. All right, section 3, all right, they had a 3-pronged response to the defense's response. The trial court made proper evidentiary rulings. The trial court's evidentiary rulings were correct and did not deprive Allen of his right to present a defense. Trial judges are better at making evidentiary calls than appellate judges, says the state. Therefore, trial courts are given, quote, wide deference, end quote, in this area. In, quote, many cases, end quote, a court could, quote, admit or exclude evidence, and an appellate court won't meddle with that decision on appeal, end quote. They talk about some cases here. An erroneous evidentiary ruling is harmless if, given all the evidence in the case, the error's probable impact does not undermine confidence in the outcome. Again, some of these things are how do you know? We have to ask, how do you know? Federal constitutional errors must be harmless beyond a reasonable doubt, meaning they, quote, did not contribute to the verdict, end quote. The constitutional right to present a defense, quote, is not absolute, end quote. That's interesting, right? Defendants must comply with well-established rules of evidence, quote, to assure both fairness and reliability in the ascertainment of guilt and innocence, end quote. The right to present a defense trumps an evidentiary rule only when the rule is, quote, arbitrary, end quote, or, quote, disproportionate to the purposes it is designed to serve, end quote. Evidence Rule 403 and hearsay rules do not unconstitutionally limit the right to present a defense. So they're saying the trial court properly excluded inadmissible evidence. The investigatory sketch of Bridge Guy. I believe this is Blair's picture, the younger looking one. It says Allen has waived this issue. The trial court granted the state's motion in limine to exclude the police sketch drawn from Blair's description of the man she saw on the bridge. Rulings on motion in limine do not preserve errors for appeal. Allen did not attempt to introduce Blair's sketch at trial, so he waived the issue. Remember, we talked about it in previous videos. If you don't bring it up, it's not on the record. It's not available as something you can challenge. Waiver notwithstanding, says the state, Blair's police sketch was inadmissible. Allen sought to admit Blair's sketch as substantive evidence that Blair did not see Allen on the bridge. But the sketch was not relevant for this purpose because, as the trial court noted and Allen concedes, Blair did not make an eyewitness identification of Allen as the man on the bridge. So I guess what they're saying is there would have to be a nexus between, yes, this is the man I saw on the bridge, and that is Allen. Blair identified Bridge Guy, my air quotes, as the man she saw on the platform of the bridge. She did not identify Allen as the Bridge Guy. Allen's identification as Bridge Guy came from Allen identifying himself as the man Wilbur and Voorhees saw, parentheses, and identified as Bridge Guy, end parentheses, and placing himself on the platform at the right time to be the man Blair saw there. So if she would have said, he's the guy I saw, the state's saying that would be different, okay? Further, any slight probative value was substantially outweighed by the danger of unfair prejudice and confusion. It was undisputed that composite sketches are used as an investigatory tool to generate leads and are not used to identify or exclude a suspect. It's only lead generation. Blair's sketch was an artist's interpretation of her description of Bridge Guy, and it was impossible to remove artist bias. Wow, that's interesting. Okay. The danger of unfair prejudice was twofold. One, the jury could misuse the unreliable sketch as substantive evidence. Okay, who's saying it's unreliable? Is the state saying it's unreliable or the witness is saying it's unreliable? How is it biased by the artist? I'm just asking these questions. How is it the artist's bias when Blair said it was 10 out of 10? So interesting, huh? And number two, the jury could misuse the sketch to exclude Allen when Blair had not purported to identify Allen. Allen's use of the sketch would have misled and confused the jury. That's interesting. That's so interesting to me. All right, we've got some footnotes here. Allen's additional arguments that Blair's sketch would impeach Carbaugh's identification or show bias in the investigation are waived because he did not make those arguments below. And Allen did not offer any foundation from Blair's sketch artist for admission of this sketch. The sketch was also inadmissible hearsay. Now, this is what we heard, right, when we were examining the defense one or in the beginning of this state's response about hearsay. Evidence Rule 801, subsection D1C, allows a prior statement of identification because these statements are believed to be reliable. Blair's sketch was not a prior identification of Allen, so she could not use it as substantive evidence that she did not identify him. This rule is a means of positive identification shortly after perceiving the person. It would not apply to a prior identification of a different person. Allen's new claim that the sketch was impeachment evidence is waived. He did not offer it for that reason or attempt to impeach Blair with it. Moreover, it would have been cumulative. On cross-examination, Blair testified that she had described the man she saw as young, boyish man in his 20s or 30s of average height with brown, quote, poofy, end quote, hair and no visible facial hair or hat. The jury could compare this description with Bridge Guy and with Allen. Allen makes no persuasive argument that the sketch would have been any more impeaching than Blair's description of the person. So typically when you want to impeach people, you impeach them based on things they prior said or did, that they're not continuously accurate. Okay, so that one has to be believed more over the other, and there could be discrepancy, right? So I think that's what they're saying here, that she never changed it. We have here 24 Allen's arguments. In our footnote here. Allen's arguments on appeal that the sketch was admissible because it was not a, quote, statement, end quote, under the hearsay rule, and that it was an adoptive admission by the Indiana State Police are waived because he did not raise these arguments for admission below. It sounds like a lot of procedural stuff the state is saying the defense failed at, okay? Number 25, Allen's reliance on Roe v. State is misplaced. There, the sketch was admitted to impeach the identifying witness's identification of the defendant. Here, Blair did not identify Allen, so there was no identification of the defendant to impeach. And they say also that, as argued in Section B below, any error was harmless due to the overwhelming evidence of guilt, which again, the state is saying Allen did it to himself. He incriminated himself on multiple occasions, okay? Tobin's testimony. Tobin's testimony was inadmissible because it was not relevant to an issue before the jury. And this is where they were talking about the methodology used for the Toolmark identification to show what I believe is the extraction of the round from the gun. Toolmark identification has at least two subdisciplines, metallurgy and firearms identification. ISP forensic firearms examiner Melissa Oberg testified that she used the Association of Firearm and Toolmark Examiners, AFTE, Toolmark identification methodology and opined, she gave her opinion, that there were 3 different Toolmark areas of significant agreement to show that the cartridge at the scene had been cycled through Allen's Sig Sauer model P226 40 caliber handgun. Defense expert Eric Warren, also a forensic firearms examiner who uses the AFTE methodology, testified that he reviewed Oberg's report, did not agree with her process of comparing a cycled cartridge with a fired cartridge, and found insufficient documentation to support her opinion. Now, a fired round is different from a cycled round, okay? Because it's doing 2 different things. I mean, part of one is in the cycling, but firing is completely different, okay? Allen also proffered William Tobin, an expert in metallurgy, however you say that. Tobin is an open critic of the AFTE and all firearms identification methodology. He believes the discipline is unreliable and should not be admitted in court. So is he biased? They say the trial court properly excluded his testimony because it was not relevant to an issue before the jury. Tobin's proffered testimony went to the reliability and admissibility of the firearms identification evidence. The trial court, let's see. No, let me go back here. Tobin's proffered testimony went to the reliability and admissibility of the firearms identification evidence, parentheses, noting Tobin's testimony discrediting the reliability of firearms identification generally and the AFTE theory specifically in a Fry hearing, end quote. So I'm trying to understand, did they have a Fry hearing? The trial court, not the jury, determines whether expert scientific testimony is admissible under Evidence Rule 702, subsection B, because the scientific principles upon which it rests are reliable. Allen never offered Tobin's testimony to exclude the firearms evidence based on unreliable scientific principles under Rule 702B. So I guess they didn't do a Fry challenge. Because the trial court found the firearms identification evidence admissible, it was for the jury to determine the credibility of Oberg and Warren, competing experts, which we typically have, and assign weight to the evidence. Tobin's proffered testimony was not relevant to credibility. Tobin is not trained in forensic firearms identification, does not do firearms examinations, and did not examine the evidence. Tobin was not qualified to offer testimony against the weight or credibility of the forensic identification evidence because he's a metallurgist instead of a firearms examiner, I believe is what they're saying. Allen's claim that Tobin's testimony was offered to impeach Oberg's credibility is incorrect. Allen offered Tobin's criticism to discredit the accepted established methodology under the AFTE. So they're saying he was speaking poorly or against the AFTE methodology, not Oberg, the witness. So the witness was on the stand, Oberg, right? The expert was on trial, so to speak. You know what I'm saying? On the hot seat. He wasn't attacking the witness. He was attacking the methodology. The methodology wasn't on the stand. The state continues, this criticism had nothing to do with Oberg's work specifically and her credibility as an expert. Moreover, Allen extensively cross-examined Oberg and he offered Warren's expert testimony to counter Oberg's opinion. Both Oberg and Warren acknowledged that criticism and ongoing debate in the firearms identification field by the President's Council on the Advancement of Science and Technology and the National Academy of Sciences. Thus, much of Tobin's proffered testimony criticizing firearms identification evidence was presented to the jury. For this reason, and due to the overwhelming evidence of guilt discussed in Section B below, any error in the exclusion of Tobin's testimony was harmless. Audio of Allen's movement videos in the DOC. Allen presented 15 videos of his movement within the DOC during April through June 2023 to show how the environmental conditions affected his mental health, which impacted the credibility of his confessions. The trial court sustained the state's hearsay objection to the audio of Allen's statements, so the jury saw Allen but did not hear what he said during these movement periods outside his cell. Only the video, not the audio, was relevant to present his environmental conditions. Allen's sole argument on appeal is that his statements were not hearsay under Evidence Rule 801C because the statements showed his state of mind. But Allen's statements do not facially pertain to his state of mind, and Allen's attempt to use them for that purpose shows that he was offering them for their truth. He wanted the jury to accept the substance of his statements as true reflections of the contents of his mind. A defendant who does not testify during trial, quote, cannot introduce exculpatory statements made outside of court in order to enhance his credibility, end quote, because the statements are self-serving, generally untrustworthy, and not subject to cross-examination. Allen also makes no argument to show the inadmissibility of other statements in the videos, though he clearly relies on those statements for the truth as well. Further, Allen had adequate other means to impeach Dr. Wallace's testimony, including cross-examination and his own expert witnesses. But it would not impeach Dr. Wallace's testimony about Allen's presentation on a particular day with videos of him on different days, even if audio was presented to the jury, because psychosis is fluid. This evidence was unlikely to have an impeaching effect. The jury was able to view Allen's environmental conditions and his behavior in the movement videos from April 5th to June 20th, 2023, in light of his expert witness's testimony of his psychosis and delirium. It says 26 here, the footnote. The exhibit itself has audio, but Allen muted the sound when it was published. So they're saying any error in the exclusion was harmless, as explained in section B below. Allen's other two phone calls on April 3rd, 2023. The state presented one jail call by Allen on April 3rd, 2023 at 5:14 a.m. over Allen's objection that the two other phone calls that day at 3:12 a.m. and 8:45 a.m. also had to be admitted under Evidence Rule 106, the doctrine of completeness. The trial court's ruling that each call in full met the doctrine of completeness was correct. Allen cites no authority showing otherwise. Now, it says the doctrine of completeness, but if I remember correctly, they didn't have both of the calls, right? They were like bookend calls. There was like a confession in the middle, and then they were bookend calls, and the defense said that they should have been included. It says here, the doctrine of completeness does not mean that once the state presents one full statement by a defendant, the defendant is entitled to put in any other statements he made at different times. This is stating in that court, that trial. It says, regardless, let's see, let me read this. In Hawkins v. State, it was rejected that because the state presented some entire jail calls made by defendant, she was entitled to present other ones. And then the state says, regardless, even if we were wrong, any error was harmless, as explained below. Dr. Gracian's testimony that Allen's confessions were false. Dr. Gracian testified to the effects of solitary confinement, the symptoms of delirium, and that he saw Allen exhibit systems consistent with delirium and false memories. The trial court sustained the state's objection to Dr. Gracian's testimony that Allen's confessions were false. So that the state says objection, and the trial court upheld it, so that it did not get in. It says the trial court ruled, 1, that the witness could not testify to whether Allen's statements were consistent with the facts of the case because the witness did not know the facts, and 2, it was for the jury to decide if Allen's confessions were false. None of these three bases Allen argues for admission were offered below, so he has waived those arguments. The only basis offered below was that Dr. Gracian knew the facts because he had, quote, reviewed all kinds of stuff, end quote, but this would be an insufficient foundation for an opinion. Further, Evidence Rule 704B provides that, quote, witnesses may not testify to opinions concerning intent, guilt, or innocence in a criminal case, the truth or falsity of allegations, whether a witness has testified truthfully or legal conclusions, end quote. Allen sought to present testimony from Dr. Gracian that Allen's statements in his confessions were false, which was impermissible under the rule. Okay, so it might be this part here, truth or falsity of allegations. I don't know, it could be anything because this talks about guilt or innocence, allegations, and whether somebody has testified truthfully. I'm not sure. We've got a footnote here. If Allen wished to elicit anything more than If Allen wished to elicit anything more from Dr. Gracian than his opinion that Allen made false confessions, he failed to make an offer of proof regarding any such additional testimony and has waived the claim. Okay. And then they state, the state includes a case here, Kincaid v. State, where an expert may testify generally about false confessions, but may not testify as to the truth or falsity of the defendant's confession. So they say Dr. Gracian testified that Allen's behavior and statements were consistent with delirium, so he was not denied an opportunity to present this evidence. So they're saying Dr. Gracian was allowed to talk about his opinion that Allen had delirium. So he did get that in, right? Even though he didn't get the exact other part. Allen's combination of the three alleged errors, all of which centered on the admission of his own statements to claim a systemic violation of due process, is unpersuasive. Allen fully and completely described the environmental, physical, and mental health conditions leading up to his confessions, as well as expert testimony on both the effects of Allen's confinement and his mental health. But neither Allen nor the state could present opinion evidence that Allen's confessions were true or false. That is not an unconstitutional infringement on the right to prevent a defense. As discussed in section B below, any error was also harmless. Okay, now we're going to talk about Perlmutter's testimony that the murders were ritualistic. The trial court properly excluded Perlmutter's testimony, opinion that this was a ritual killing, proffered in support of Allen's theory that this was a ritual killing committed by Odinists. All right, and we'll get to that footnote in a minute. Expert opinion testimony is admissible only when it, quote, will help the trier of fact, end quote. Rule 702 is restricted by Evidence Rule 403, which permits the exclusion of evidence that will confuse the issues or mislead the jury. Third-party motive evidence must establish more than a speculative connection to the crime to be admissible. All right. Perlmutter's opinion that this was a ritual killing, an opinion she reached before seeing any evidence in the case, that's an interesting statement, isn't it, was too speculative to be admissible as a third-party motive evidence. It was a motive in search of a suspect, as discussed in subsection below. No evidence connected any Odinists to the murders or placed them at the crime scene. It was speculative motive. There is no history of ritual human sacrifice in Odinism, and according to an Odinist, the sacrifice of children would be contrary to the principles of religion. Even Perlmutter acknowledged that apart from this case, she had knowledge of only one other Odinist ritual killing, and that case remained an open investigation with no confirmation of a perpetrator or motive, which means she actually could not identify any other example of an Odinist ritual killing. So I guess the state is saying that they would have need to have found a defendant in that case to make it definitively and maybe a guilty verdict or a guilty plea in order to make it an Odinist killing. Not sure. Perlmutter also acknowledged that the outdoor killings committed with a knife are not necessarily ritual killings. And this sounds a lot different than what the defense presented, huh? And it was a motive based on inaccuracies with respect to the alleged symbolism at the crime scene. There was no, quote, F, end quote, in blood on the tree. That was a misapprehension caused by the reddish tints in the tree bark. Okay, we didn't hear that. When a chemical was applied that turned the blood white, it was apparent there was no second horizontal line necessary to form an F. Okay, the blood formed only an upside down, quote, L, end quote. And neither Perlmutter nor Allen have ever contended that an upside down, quote, L, end quote, is a rune or Odinist symbol. Sounds different now, doesn't it? The blood patterns on the bodies and on the ground were inconsistent with the bodies having been hung upside down, as Odin is typically depicted. Okay, that's different too. The sticks on the bodies were, quote, fundamentally ambiguous, end quote. Professor Turco found it equally plausible that they were not attempted runes at all and could offer only, quote, conjecture, end quote, as to their meaning, if it was assumed arguendo that they were intended to be runes, as the arrangements of the sticks, quote, did not in any obvious way spell a word, end quote. As seen in the crime scene photographs, the sticks were, quote, much less suggestive, end quote, of runes than in the police sketch he was initially shown. With respect to the sticks on LG, even Perlmutter could only say that she believed they had, quote, specific meaning to the offender, end quote. She could not identify any rune or symbol that they purportedly formed. The FBI's behavioral analyst unit was, quote, unable to verify or find support for, end quote, the theory that this was an Odinist killing, determining that neither the blood on the tree nor the sticks on the bodies, quote, clearly depict, capture, or present known aspects of Odinism or its symbology, end quote. Now that's a little different than the way what the BAU, the Behavioral Analysis Unit, the BAU, supposedly said, right? Right? Because I think they said they couldn't say it wasn't, right? And here, unable to verify or find support for, that sounds a little different, doesn't it? Particularly in the absence of any evidence placing any Odinist at the crime scene or directly connecting to the crime, the trial court acted well within its discretion in declining to admit evidence of a speculative alternative motive that would have confused the issues, turning the trial into a sideshow debate over disputed claims of Odinic symbology and distracted the jury from the issue before it, namely whether the evidence proved Allen committed these murders. That is especially true because motive was not a basis through which the state purported to identify Allen as the perpetrator. Okay, they're saying it wasn't the motive. Because motive was not a significant factor in the proof of guilt, the probative value of evidence of an alternative motive was correspondingly low and easily outweighed by the dangers of confusing the issues and misleading the jury. Okay, so since they weren't going to motive, it wasn't coming in. And we got a footnote here. Contrary to Allen's representation, Perlmutter testified that the sticks on AW, parentheses, not the sticks on LG, were the, quote, bind rune, end quote, which she theorized combined a, quote, Gebo, end quote, rune and a, quote, Isa, end quote, rune based on a Facebook posting and a picture by Brad Holder. Perlmutter's ritual killing opinion was inextricably intertwined with her assessment of things depicted on Holder's social media, but as shown below, Holder was definitively cleared as a suspect. Okay. All right, as discussed in section B below, any error was harmless. Evidence of two third-party suspects. The trial court properly excluded Allen's proffered alternative suspect evidence pertaining to Brad Holder and Patrick Westphal. Allen was permitted to present evidence challenging the quality of the police investigation and their long-term suspicion that more than one individual had been involved in the crime. But the court excluded his specific third-party suspect evidence because Allen failed to establish any nexus between those individuals and the crimes. To be admissible, evidence must be relevant. It must tend to make a fact of consequence more or less probable than it would be otherwise. And that's Rule of Evidence 401. quote, evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime and thus meets the definition of relevance in Rule 401. Okay, so we've got a footnote here. Below, Allen asserted that several other individuals acted in concert with Holder and Westphal to commit the ritual killing. He never claimed below that Holder and Westphal had acted alone. Okay. On appeal, he has abandoned any claim that the evidence pertaining to those other individuals should have been admitted. Relevant evidence may be excluded if its probative value is outweighed by unfair prejudice, confusion of issues, and the potential to mislead the jury. Evidence Rule 403, or by its failure to satisfy any other evidence rule. Third-party suspect evidence is excludable under Rule 403 unless the defendant shows, quote, some connection between the third party and the crime, end quote. So, they're going down through these cases. So they're saying that it needs to be the nexus, right? The police investigated Holder and Westphal and never found any evidence connecting them, parentheses, or any other alleged Odinist conspirator, end quote, or end parentheses, to the murders or placing them at the High Bridge Trail that afternoon. And Allen's proffered evidence amounting largely to evidence that they were adherents of Odinism and that the sticks placed on the girls' bodies were purportedly in configuration similar to, quote, runes, end quote, on Holder's social media, falls far short of creating a non-speculative connection to the crime. Holder had a confirmed alibi that made it impossible for him to have kidnapped or murdered the girls shortly after 2 p.m. on February 13, 2017. Quote, opportunity is the one logically essential type, end quote, of evidence, quote, a defendant must produce in order to have any chance, end quote, of admitting third-party suspect evidence. So if you're going to throw that other person under the bus, they had to have been able to do it, right? You just can't toss a name out. When he was interviewed by police on February 17, 2017, Holder said he was at work on February 13th and then went to his gym in Logansport where he lived. Holder worked at a landfill in Buffalo, Indiana. His work records confirm that he was at work on February 13th from 4:55 a.m. to 2:45 p.m. And his gym record showed that he checked in there at 4:08 p.m. on February 13th. So, what did he do from 2:45 to 4:08? The operations clerk for the landfill, the only person who could make changes to the electronic time records, confirmed that she had not changed Holder's record. And she confirmed that it would not be possible for him to be absent while his time card showed he was present. So I guess they're going with the video, that, what is it, the 213 video of Bridge Guy. Okay. Only a small number of people worked each shift, and it would be immediately noticed if someone was absent or left early, or if a stranger was there. The equipment ran continuously, and if one person ceased working, it would affect the entire operation. Specialized training was needed to operate the equipment, further precluding the possibility that Holder could have sent someone to take his place at work that day. Because Holder could not have committed the crimes, no evidence about his Odinism or his social media could have any tendency to decrease the probability that Allen committed the crimes. Let's go back up here. Footnote 31. Holder's son, who had been, quote, talking, end quote, to AW, also had a confirmed alibi. He was in school in Logansport that day. 32. Buffalo is located 25 miles from Delphi. It takes 30 to 35 minutes to drive from Buffalo to the High Bridge area of Delphi. So, if he would have left work at 2:45, he would have been there about 3:15. Right? Okay. Okay. Without Holder, the theorized connection to Westphal necessarily fails. It was a central tenet of Allen's ritual killing theory that the crimes were not committed by one person. He never contended below that Westphal committed the crimes by himself. Westfall's alibi that he was with his son that afternoon was corroborated by his son. Holder's ex-wife's statements that Holder said Westfall murdered AW or was involved in the murders, statements Holder denied making, were inadmissible hearsay. And that's an ex-wife. We don't know what happened with that. Apart from that, Allen points to nothing other than the fact that Westfall was an Odinist. At best, this is weak, speculative motive evidence predicated on a speculative and inaccurate reading of the crime scene. This speculative theorizing, lacking any admissible evidence directly connecting either man to the crimes, does not rise to the level of admissible third-party evidence. They would have to show the nexus, right? As discussed in section B below, any error was harmless. Okay, harmless error. Any of these alleged errors, individually or collectively, is harmless given the powerful independent evidence of guilt. Okay? Remember, they're not going with the eyewitnesses and all the stuff that they said. They're using what Allen said. The timeline and eyewitness evidence, including Allen's initial statements to police, creates an overwhelming certainty that Allen was Bridge Guy, parentheses, and thus the murderer, end parentheses. Allen admitted he parked near the Freedom Bridge entrance and began walking the trail about 1:30 p.m., which was corroborated by the surveillance video capturing a car matching the appearance of his Focus driving towards the Freedom Bridge entrance at 1:27 p.m. He admitted he was wearing a dark Carhartt jacket with a hood, blue jeans, or either tennis shoes or work boots, and he had a hat with him, which matched the clothing worn by Bridge Guy. Allen identified himself as the man who walked past the Wilbur Voorhees group on the trail around 1:30 p.m. Wilbur and Voorhees both immediately recognized the picture of Bridge Guy as the man who had walked past them. Allen also admitted that when he reached High Bridge, he walked out to the first platform and stayed there for a few minutes. Blair entered the trail at the Mears entrance at or just after 1:46 p.m. Remember, she had her Fitbit or something. And when she reached High Bridge, she saw a man on the platform whom she immediately recognized as Bridge Guy. Neither Blair, Wilbur, nor Voorhees saw anyone else on the trail who could have been Bridge Guy, parentheses, or Allen. And Allen acknowledged seeing no one else who could have been Bridge Guy. As she walked back towards the entrance, Blair passed AW and LG on their way to High Bridge. And by 2:13 p.m., the man Blair, Wilbur, and Voorhees saw, the man Allen had effectively identified himself as being, was following AW and LG across High Bridge, ordering them, quote, down the hill, end quote. By 2:32 p.m., LG's phone had stopped moving, and by 3:11 p.m., LG was not answering the phone when her father called, and she and AW had failed to meet him when he arrived to pick them up. Shortly before 4 p.m., Carbaugh saw a man she recognized as Bridge Guy walking westbound on CR 300 North, i.e., toward where Allen admitted he had parked his car. His clothes were covered in mud and fresh blood spatter. Given Allen's admissions placing him on the trail and on the High Bridge platform at the right times to be the man seen by Blair, Wilbur, and Voorhees, their certainty that the man they saw was Bridge Guy, the absence of anyone else on the trail who could have been Allen or Bridge Guy, and the tight timeline this combined evidence created in connection to the abduction and murders, the only reasonable conclusion to be drawn was that Allen was Bridge Guy, the person who murdered AW and LG. Other evidence corroborated this conclusion. The .40 caliber cartridge found by the girls' bodies was forensically matched as having been cycled through Allen's .40 caliber handgun. Allen had an identical unfired cartridge, the only piece of Winchester ammunition found in his house, in a keepsake box. Allen had no possible innocent explanation for how a cartridge that had been in his gun could have ended up at the murder scene. Bridge Guy had a gun and used it to compel AW and LG to go down the hill. An ISP trooper who had listened to over 700 of Allen's phone calls opined that it was Allen's voice heard on the video saying, quote, down the hill, end quote. Although Allen had 12 old cell phones in his bedroom closet, he did not have the cell phone he told police he had with him on the trail in 2017, creating a reasonable inference that he destroyed the phone because he knew it contained evidence of his guilt. Allen also displayed consciousness of guilt by lying to the police. Although he originally told police he was at the trail from 1:30 to 3:30 p.m., parentheses, and the testimony of Wilbur and Voorhees proves that he was arriving at the trail, not leaving it, at 1:30 p.m., and parentheses, when the police re-interviewed him in October 2022, Allen claimed he was at the trail much earlier, from 12 to 1 to 1:30 p.m., showing he understood the damning implication of the initial timeline he had admitted. While police executed the search warrant at his house, Allen said multiple times, quote, "It's over," end quote. Allen confessed to killing AW and LG multiple times. He explained that he was frightened by a van driving past, causing him to abort the intended rapes and kill the girls, a detail only the killer would know that was corroborated by Weber's testimony that he arrived home from work in his van shortly after the girls were found forced down the hill. The evidence of guilt was conclusive and irrefutable. Moreover, as has been referenced throughout, Allen subjected the state's case to adversarial testing by presenting evidence of inconsistencies between eyewitness descriptions of Bridge Guy and Allen's appearance, and between eyewitness descriptions of the car parked at CPS building and Allen's Focus. Expert testimony challenging the validity of the ballistics match, the length of time Allen was held in restrictive housing, DOC policy on restrictive housing and its effects on mental health, expert and lay testimony regarding Allen's mental health at the time of the confessions, and video evidence of Allen's behaviors around the time of the confessions, and evidence that LG's phone data showed a headphone connection in the audio output during the evening of the 13th that was not explained by the state's theories of the crimes. If those attacks failed to cause even one juror to have reasonable doubt, then this court can be confident that none of the comparatively insignificant pieces of excluded evidence complained about here would have made any difference to the verdict either. Again, this is our state saying this, the state of Indiana. C. Admission of a possible explanation for cell phone code was harmless. The admission of the Google search was at most harmless. We've heard that word a lot. Defense witness Stacey Eldridge opined that between 5:45 p.m. and 10:32 p.m., LG's cell phone registered a code in the, quote, knowledge C, end quote, database of an, quote, audio output start, end quote, which indicated that headphones or an auxiliary cable was plugged into the phone. She opined that this event required human interaction, which Allen offered to suggest that someone else committed the murders because Carbaugh saw him leave the scene by 4 p.m. There was some water and debris on the phone when it was found. To Eldridge's knowledge, water would not affect the plug-in data. The state's two cell phone experts, parentheses, Christopher Cecil and Brian Brunner, and parentheses, testified that they do not know what a, quote, audio output start, end quote, meant. On cross-examination, the state asked Cecil if he had done a Google search to determine if water damage could cause the audio output code. Allen unsuccessfully ejected on hearsay grounds. Cecil testified that he found through that search that water damage or dirt within the headphone plug-in could cause the phone to register an audio output. Cecil acknowledged that he does not normally do Google research and that information on the internet can be wrong. Okay, so when these cell phone experts get up, especially if you watch the Karen Reed case, all this stuff about what was doing what, at what time, where the memory was stored, where all this stuff was. So it sounds like the state's witness said, I never heard about this output error. Like with your car, you know, when your check engine light comes in, you take it in, they plug it in, they tell you what's going on with it, what error code, or like on your computer. Here, I'm looking at my computer and people say, well, what does the error say? What's it telling you? So the state is saying our people never heard that thing before, so they Googled it. Okay, that they didn't know what it was. And so apparently, I'm assuming, in the Cellbrite or whatever software they're using, there isn't one listed. They've never experienced that or thought to enter it in their training curriculum or their dictionary of error codes or whatever. So the guy had to Google it. The information was proffered as an alternate theory of the cause of the audio output code, but neither of these theories made it more or less probable that Allen committed the murders. As argued above, Allen's identity was proven through eyewitness testimony. Now they said they didn't use that, right? Allen's statements to police, the cartridge from his gun found between the bodies, and his confessions. That's interesting because they didn't say that, right? Didn't they just say that it was his statements alone? The health app data showed the phone did not move after 2:32 p.m., defeating any suggestion that the phone was returned to the crime scene after 10:30 p.m., parentheses, which in any event would not preclude Allen being the perpetrator, end quote. I guess they're saying maybe he could have taken it with him. And any suggestion that another person was present at the murder scene at 5:45 p.m. and 10:32 p.m. during the height of the search of the girls, which would, I guess, been in the area. Again, I don't know about the case. Inserting and unplugging headphones from the phone was implausible. The evidence had no bearing on the verdicts and was harmless error. 4. The trial court properly denied Allen's motive to correct the error. The trial court properly denied Allen's motion to correct the error because the state did not knowingly present false testimony through Waiver in violation of Napue versus Illinois. A conviction obtained through the use of evidence that the state knows is false and does not attempt to correct violates a defendant's Fourth Amendment due process rights. To make a claim under Napue, I don't know if I'm saying that right, the defendant must establish that there was false testimony, the government knew or should have known it was false, and there is a reasonable likelihood that the false testimony affected the judgment of the fact finder. Allen failed to show that the state presented false testimony through Waiver. Allen's argument is predicated on surveillance video he claims shows Weber's van arriving home at 2:44 p.m. But Allen did not present any verification that the date and timestamp on the video was accurate. So if they're saying that he came home, if the defense is saying he came home at 2:44 p.m., the state is saying you should have shown us the timestamp. It is common for timestamps on surveillance videos to be inaccurate by minutes or hours. Yes, absolutely. I see it all the time. For example, the Hoosier Harvest Store surveillance video was 54 minutes fast. Allen admitted that the camera's timestamp was inaccurate as it showed bright daylight when the timestamp indicated the middle of the night. There is no basis to assume, as Allen does in his argument, that the only inaccuracy was a precise 12-hour difference or that it was 12 hours slow rather than fast. Absent verification of date and time and absent proof that the vehicle on the video is Weber's van, Allen cannot show that Weber's testimony that he drove straight home in his white van after clocking out of work at 2:02 p.m. was demonstrably false. Allen also offered no foundation to support the quote ping end quote evidence in the FBI report. Without evidence as to whether or when Waiver had his cell phone turned on, the absence of a quote ping end quote earlier does not prove he was not home earlier. Allen did not show that Weber's testimony was demonstrably false in support of his Napue claim. Allen's claim also falls on the third step of the Napue claim. In this step, hope I'm saying that name right. Napue, I don't know. In this step, reviewing courts will consider whether the defendant had an adequate opportunity to expose the false testimony on cross-examination. The state had disclosed the surveillance from Weber's video, from Weber's neighbor, and the FBI, quote, ping report to the defense prior to trial. Despite having the surveillance video at trial, Allen never asked Waiver to identify his van on that video to expose his allegedly false testimony or even to impeach him. This was presumptively a matter of trial strategy. In the defense cases, people decide to challenge and impeach witnesses at different points. Sometimes they do it in defense interviews. Sometimes they do it at hearings, constitutional challenge hearings. And sometimes they wait to, unleash the Kraken or whatever you want to call it, at trial. So, they're saying they didn't. So they say the crux of Allen's claim is that if Weber's testimony was false about his time of arrival home, then Allen's May 3rd, 2023 confession to Dr. Waller was not credible. They say this premise fails for two reasons. First, Waiver did not testify to an exact time of arrival, so Allen's evidence would have not shown that Waiver's testimony was false, only at most, quote, inconsistent, end quote, with the murder timeline. Second, the credibility of Allen's confessions was challenged with a plethora of expert evidence. The jury had ample evidence to evaluate not only Waiver's credibility, but the credibility of Allen's confessions. Allen was not denied due process. The court should affirm the denial of Allen's motion to correct the error. Okay, and then here's the conclusion of what the state says. So now I believe we have another defense rebuttal, and we might have the order granting the hearing. Okay, so I will try to find those. Comment, like, share, subscribe. Let me know your thoughts. Let me know in the community or otherwise what cases you want to talk about. Thanks for being here. I'll see you in the next one.